It is 9 a.m. From the looks of my screen, I believe we probably will be at a quorum, so I will go ahead and start the meeting. Let me make sure. Joy Tomlinson, are you ready for us?
Yes, ma'am.
Okay, just making sure. I do see it recording at the top. So this is the date and time for the notice meeting of the Child Support Guidelines Committee for January 7th, 2022. It is 9 a.m. and I am going to do the roll call. Kathleen Baker.
Present.
Margot Chappell.
Kathy Kaplan in place of Margot Chappell.
Thank you. Karen Cliff.
Present.
Assemblywoman Cohen.
Here.
Ellen Crecilius.
I'm here.
Jack Fleeman. Assemblywoman Hardy. Senator Harris. Judge Hoskin.
I am here.
Senator Pickard.
I am here as well.
Judge Robb.
Present.
Joseph Sanford.
Present.
Judge Shirley. And Justice Stiglitz. We have 10 present, making this a quorum. As a reminder, the Deputy Attorney General has informed us that we have to have our cameras on to have it be a valid public administrative meeting. So if you do not have your camera on, and it may just be the fact that I can't tell on my screen, but turn it on if it is not on at this time. We will move on to public comment. This is the general public comment. We of course have public comment throughout the agenda for each of the agenda items. Your public comment will be limited to 2 minutes. If we can now please take public comment.
To give public comment, please raise your hand in the Teams meeting or press *5 on your phone to take your place in the queue. I'm showing no hands are raised at this time, and then also Dallas Harris just entered the meeting as well.
Okay, thank you. Senator Harris, are you with us?
I am. Good morning. Give me just
Good
a second and I'll figure out how to work this camera.
Beautiful, thank you. All right, so a couple of administrative items. One, I know we have a clunky agenda today, but it is the best I could do with the AML materials and to try to navigate us through them, but we'll discuss that again in a moment. As far as approval of meeting minutes, I asked DWSS staff to go and talk to our Deputy Attorney General in charge of our meetings and find out if the transcripts were in fact compliant for meeting minutes, and they have informed us they are not. So we will be redoing and actually creating actual meeting minutes for the last few meetings in which we use transcripts for the meeting minutes. And we will get those out to everybody. That means that for today, we are not going to be doing approval of the meeting minutes, and we will move on to do those at the next meeting. As far as organization for today's meeting and moving through the agenda, I'm not clear as to whether or not, because we don't get a chance to talk as a committee till we're in these meetings, whether this was sufficient time for you to go through the materials that were provided at the last meeting or not. If we're ready to proceed with this agenda, but if you feel that items need additional time, just inform me as I move through the agenda, and we will go on from there. So the first agenda item is agenda item number 4, discussion and recommendations on the master document for approved language changes. I've created the master document. The only changes we have so far are the changes regarding, I'm looking at this master document. It's not showing the edits like the one I had did. Can you guys see the red lines in it? In the master document?
No, I was actually going to, this is Keith Pickard for the record. I was going to ask a question as to whether or not we have adopted any because I don't see any red lines. So, yeah.
Yeah, I think that's a mistake because I do have a document with red lines in it and this document is not demonstrating them. So we will move on to a different agenda item for now and I will get that accurately sent out to the committee. I do have one, it is redlined. The two items in it are regarding the public assistance language and within gross income regarding self-employed. All right, agenda item number 5, discussion and recommendations, clarification of NAC 425.025-1M, the inclusion of alimony and gross income in the regulations versus NAC 425.0252 that does not exclude or deduct alimony paid from the obligor's income. All right. Like I said, we have a clunky agenda today, and so I'm going to do my best to navigate through it with you guys. We've got a couple of things on our plate. We've got the changes from the AAML. We had public comment email that I believe everybody received. Did everybody receive the public exhibit from Ms. Woods? Am I getting, okay. Now I can see the shaking heads. I'm working off of multiple monitors to get this to go forward. So we've got that. We've got some edits from Senator Pickard, who also commented that really it was Judge Hoskin who made the edits at the beginning of the meeting. And then we've got a new issue that has arisen that I have added to the agenda. Are we prepared to discuss alimony today on agenda item number 5?
I am prepared, and as an overall procedure, Madam Chair, and this is Bridget Robb for the record, could I suggest that we take the smaller issues, resolve those, and then wrap them into the larger AAML changes?
Yes. Depends on what you decide as minor issues. Is this one of them?
Rather than minor, shall I say discrete or isolated issues?
Okay, there we go. Okay, yes, we can do that. So do we want to discuss number 5 right now or move it off to later?
I'm okay with moving forward because this, I think, is pretty straightforward, but that's my opinion. Keith Pickard for the record.
Okay. Let's move then. Let's talk specifically about the email from our public comment from Kimberly Woods. So we will start with agenda item number 7, in which she stated it's discussion and recommendations on NAC 425.025 1B to determine if not including the principal means the gross income should not be reduced by investment losses. And in her email, she states, does this need to be clarified? Any comments on this item?
Madam Chair.
Oh, I don't want to do all the talking, Keith Pickard for the record, but I will say that I think what, and this is something that I struggled with when we went through this in the first iteration. I'm no expert in tax law, but you know, I've walked around these swamps long enough. What I think we were trying to get at, and so I think maybe it might be helpful to have somebody like Ms. Woods step in and help us by telling us how best to accomplish the goal, because we were all kind of, I don't know, we probably have some tax experienced people on the panel, but what we're trying to do is if someone's getting income, if they're getting money out of the business, we want to capture that. And the tax laws are really a blunt instrument in doing that. If you recall, when I suggested we use the tax law as a proxy for all those components of income, which was roundly shouted down, because it is a blunt instrument, it doesn't make for a good proxy. And of course, I have become convinced that that was the right move, that we not use tax. And so I'm starting to wonder, especially after seeing this and after having similar experiences, I think our reference to the tax law is more problematic than it's helpful. And I don't know, I'd love to hear from the judges and particularly the 4D program, but I suspect the judges will have more experience because my expectation is most of the people that are caught up in the 4D program don't have complex tax situations that are coming to play. But, my thought is that, and I just, by way of an aside, I just had a case. We're in the midst of a reconsideration, but I had a case where it was a personal injury attorney on the other side, and she was able to deduct her car, her vacuum cleaner, her coffee machine, a whole host of personal expenses, which the court found were personal expenses, and so added them back, and they're coming back with this language suggesting that, hey, wait a minute, the guidelines contemplate some of these depreciable assets as reductions to income. And yet, these are personal expenses that the average person would never be able to claim. I would love to, although I don't have a car payment, I would love to be able to deduct my car payment from other obligations, right? It just doesn't make sense for us to be doing that. So I think that this opens the door, and again, this is my personal view, but I think this opens the door to the broader discussion of should we be referencing the tax law at all? Is there a better way to do this? And I think bringing Ms. Woods in, she's offered to help, bringing her in to maybe get some insight would be very helpful.
Madam Chair, this is Bridget Robb. In looking just at Ms. Wood's comments holistically, they raise a problem for me. At the beginning of this, one of our very first, I believe, issues of discussion was what is gross income and is that pre-tax or post-tax? We had a pretty robust discussion about whether it should be fairly post-tax. And we came to the conclusion that there were so many ways to, for lack of a better term, game what is post-tax and the ability to load up on things to reduce your income, that we didn't want to do that, which is why we stayed with the pre-tax concept. Here, she's talking about going away from even the tax code and looking at GAAP. And I am absolutely opposed to that. We should not be rewarding people who have better accountants and reducing their child support on that basis. This again is similarly children being treated very differently depending on who the professional is. And so I think we, as a policy matter, I think we need to keep that in mind that as Senator Pickard stated, we're really looking to capture income, but do so fairly. Business expenses, if you have legitimate business expenses, I've always said if you have your own business, I look at those. But personal expenses run through a business, that's not a business expense. And that's not, your child should not be paying for your car. And so that's kind of the way I've always conceptualized this. And I thought that's what we had come to when we looked at this the first time.
I absolutely back exactly those statements. My my concern when I read this is that, you know, a CPA firm was hired to calculate gross income for the purpose of a divorce case. And it triggers me. It triggered me the same way, kind of comments you made, Judge, which is just, it's that trigger of, so we're trying to hide income, right? We're trying to figure, like, get down to brass knuckles. If we take what we did in the guidelines, the theory, you know, if you take somebody's living 100% off the interest of a large investment account, and they're living off that interest, and they're gaining it each month, and it really is what they live off of. The assets that's sitting there and not moving, that's earning that income, is what we didn't want to include. That's a very clean, pure, non-CPA way of looking at it, right? That is the legal way of looking at it. And so now we've got all of this blurriness with the accountants with these questions. And I agree, it concerns me that maybe it needs to be reworked. Maybe we didn't approach the language right. I don't feel as an attorney it's been that difficult to apply the guidelines and think through this the way we normally have, because this was an issue before the change of the guidelines. This is not a new issue for us. This is not something we've not dealt with in our cases. And when we have someone try to muddy the waters and use a CPA to make it confusing or to clarify, not just make it confusing, then great, it works. We make it work in those litigation cases. I greatly doubt, and I mean, I could be completely wrong on this, but Mr. Sanford, Ms. Cliff, Ms. Baker, I don't know that you're dealing with this issue all that often like we are on the private side with our cases. Additional comments?
Joe Sanford for the record. I guess I'll state it is rare for us to have significant issues with this. It does come up on occasion, at least at where I am in the rural areas. If we do get it, a lot of times it's a farm operation, which actually I think comes back to one of the issues that has been raised by the other members of the committee, which is generally farming stuff is an incredibly tax advantaged type of business. The ability to claim significant depreciation is there. Almost every farm everywhere is able to show a loss every year. Yeah, and so it can actually be very difficult when you show a loss for 15 years in a row, but obviously
You're living.
Obviously that isn't entirely true, and so the tax code isn't always the best method of determining whether or not say some of these operations are actually functionally making any money and allowing people to live. And so I can't say that I'm a tax professional. It doesn't come up that often in our cases. Would be happy to listen to anybody who wanted to come in and say this is a better way. Like we've said before in our other cases, if someone would actually propose language specifically that I think might be more helpful than some other things. But I guess I would say it's pretty rare. But we do have it come up, and when we do have it come up, I do agree that sometimes the tax code itself is not a good measure for whether or not something is or is not actually working as income.
This is Karen for Clark County. I agree, we don't see a lot of these cases, but we do still see quite a few because we are establishing and modifying cases with self-employed individuals. They're complicated cases, no matter how you slice it and whatever standard you're using. It's complicated, but I'm not inclined to implement the GAAP standard. My personal preference is we leave it alone. But all of you see, of course, much more than we do, and if that's what's in the best interest of these cases, we can discuss it. But my feeling is just leave it alone. That's Clark's.
Kathleen Baker from Washoe County. I would concur with both what Mr. Sanford and Ms. Cliff indicated. We do see in our self-employed individuals who come in, but I think that the way that we have it worded now seems to be working relatively well in determining what the gross income for these parties are for the purposes of child support. And I think it's very easy to use the tax code where you can take deductions so that you pay less taxes on the income that you have. But I don't think that accurately reflects what your income is for the purposes of calculating child support. So I'm not in favor of making it more complicated, again, deferring to what private counsel may need.
Madam Chair, if I could just briefly, Judge Hoskin, I don't want to dissuade Ms. Woods. When I reviewed this, I found that it was an interesting argument for an individual case, but a very poor argument for a global modification. Certainly, the discretion we built into the guidelines allows the court, in my opinion, to take a look at all these arguments and make a determination with regard to that specific case. I think the problem would run in if we take specific cases and then globally try and apply it. I think we cause problems. So I agree with what everybody has said. I don't think we ought to mess with it, but I don't want to have Ms. Woods walk away feeling like she didn't submit something. It's an interesting argument. It's an argument that I would love to consider on an individual basis if I have the discretion to do it, and I believe I do under the way that it's written currently.
Additional committee comments?
Yeah, Keith Pickard for the record. I agree with the sentiment. I will add that when I went through her email and I went back to the language, I was wondering if we really need to get into the language of undistributed income, particularly where we are specific enough to say reasonable allowance for economic depreciation, and then we define that, and we define it by pointing to federal income tax laws. And so she raises a good question, and I see this with some regularity as we're trying to get to what are personal expenses and what are legitimate business expenses. My reaction after reading her email was to say, why don't we simplify this and just say, undistributed income includes, and I haven't thought through the language necessarily, but it includes all income that the business incurs after reasonable and necessary expenses, just like we do on the FDF side, on the personal expense side. That way it becomes more of a factual consideration by the court as to what is a reasonable and necessary expense of the business. Depreciation on things is certainly a reasonable and necessary expense. It's usually an upfront expense, and so where we want to make sure that we're not allowing for somebody to deduct 100% of, say, that combine or the tractor or the rooftop unit on the building, whatever it may be, we don't want that to come out of 1 year entirely. But then it just becomes a factual situation for the courts, and it simplifies it. We're now taking away the ability to say, hey, look, you said right here in the language of the statute or of the regulation that I get to depreciate, or I get to reduce my income based on the federal income tax law. Well, we can simplify that and say, you get to deduct the reasonable and necessary expenses of the business and leave it up to the court. I mean, I just had half a day of trial on this very issue, and we were able to demonstrate what those declared expenses were, and the judge agreed these are personal expenses and disallowed them. So we got to the same place. But I think that what Ms. Woods is pointing to is we've incorporated a reference to the federal tax law that has ultimately made it more difficult to decide. Anyway, that was my impression.
Okay, additional committee comments? Hearing none, does anybody want to make a motion, or from the feel of the conversation, obviously it's that we not make any changes, but just in case.
Well, I would like to table it and let this percolate a little bit, and particularly as we discuss other things, with the preference to leave it alone, certainly not incorporate GAP. I agree. That would open the door to a lot more mischief, in my view. But I think as we go through the rest of the changes, I would like to come back to this after it percolates a bit. That's my personal preference.
Okay, I don't have a problem with that. For clarification of the record, we have in fact combined and discussed agenda items 7, 8, and 9, all as the result of Kimberly Wood's email that was sent on December 10th, 2021. And I can table this for now and keep it for future discussions. Any further discussion before I move on to another agenda item? All right.
Madam Chair.
For the record,
Sorry, go ahead.
Go ahead.
I was just say that I believe we addressed the number 2 and 3 of her email. Number 1 was actually a separate piece relating to not including the principal of investment income. It didn't get discussed. I generally haven't had this actually come up in any of our cases at all, but I have had members of the public express some concerns about what this means in terms of investment gains and investment losses, especially as it relates to unrealized income gains, and whether that's supposed to be checked year by year. I have to imagine you guys get a lot more of that than I do. And so I just thought if we were going to address it, maybe this would be a good time. So I'll let the private folks who deal with this a lot more often maybe see whether it's actually been a problem other than just people who have mentioned it to me but haven't had a discrete case with it.
Senator?
Thank you, Keith Pickard, again for the record. In the times that I've dealt with this, the losses, the investment losses usually don't result in in something. Well, it results in a reduction in income. In that, if you have a loss to a particular investment account, say it drops by 25%, what that does, because we're not dealing directly with the principal, it's an indirect effect on the outcome, right? Because we're not looking at the gain or loss to the principal as a measure of income. It's the income derived from the account. So if I have $1 million sitting in an account and I'm pulling the interest off of that to live on, as the chairwoman mentioned at the beginning, that's the income. It's the investment income. It's not the gain or loss on the principal amount itself. So my answer to number 1 is no. We don't want to be reducing income from investment losses, because the investment loss, the principal, isn't income. The gain, if you're pulling that out of the investment, then yeah, that would be income. But it's the income that's coming from the investment, not the gains or the losses. But maybe I'm mistaken on that.
Judge Rob?
I understand the regulation to say exactly what Senator Pickard was talking about. And it occurs to me that when you experience loss, you are going to receive the benefit of that because you're going to be paying less tax. And so I am with the senator. I want to leave this alone.
Additional comments? I'll say I'm back to my initial comments when we were really dealing with number 7 on the agenda versus expanding our horizons. I'm also inclined to leave it alone. I think, quite honestly, on case-by-case basis, exactly as Judge Hoskins said, it's up for us to argue in court, and the different means in which we figure out how to argue that is up to us. But if somebody has enough investment income to be making that argument and hiring a lawyer to make that argument and fighting paying their child support or any child support based on the fact that they had some losses for the year, well, you know, it's that's for dispute in court. They're able to do it. They have the means to do it. And I don't know how we could fine tune this enough to not, this is a good example that if you say you're going to reduce it by investment losses, that the unintended consequences of that is what scares me, of what we would lose and what loopholes that would create, that would hogtie the judges and make it impossible for them to make the right decision on it, versus the nice clean language we have right now allows them to do what they need to do and what's right. Additional comments?
Can we have a motion to remove agenda item 8 as resolved?
I think it's 7, isn't it? Let me look.
I think we were talking about 7.
Oh, okay.
But yes, we could, yes.
Yeah.
Are you making
Well,
that motion?
I'm not sure that, I think 7 and 8 are functionally similar. We're dealing with the same language. We're dealing with 0251B, just different sides of the same coin.
Right.
So I would think 7 and 8 can come off.
Okay.
And if that's a motion, I'm seconding it.
It's a
All
motion.
right. Any further discussion? All in favor, state aye.
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 Aye. Aye.
Any opposed? Any abstained? Motion passes. All right. I made a mess of my notes. Give me just a moment now, or else the next agenda will be screwed up. All right. Yeah, it was that bad. I made a mess of my notes. All right. Let's backtrack to number 6, agenda item number 6, discussion and recommendations on whether income from bonuses should be included in gross income and how the receipt of a bonus impacts child support, and in particular, the language in NAC 425.0251. And we have a committee exhibit from Senator Pickard.
Hey, Madam Chair.
A revised new version.
Yeah, interestingly enough, I had just before we went on the record, otherwise I would have had it in perpetuity. I had another judge point out, I think there must be, and Judge Hoskin, maybe you can confirm this, but it looks like there's some discussion about bonuses because at least one more judge has asked me, hey, why didn't you include bonuses and income in the guidelines? So apparently that's at least going around the South. But yeah, I mean, I think what's happened is word's gotten out that bonuses aren't specifically mentioned in the existing guidelines. And so I think that this, if nothing else, this language will make it clearer that at least for the new judges who don't have a lot of family court experience, yeah, bonuses are supposed to be part of the calculation. So we adjusted the language. You see that in the exhibit, picking up Judge Rob's suggestions as to the description. It's if such compensation is not nominal, recurring, and can be accurately determined. The rest of it is just renumbering. So I'd love to take comments, and then I'll make a motion to do pass.
Let me, sorry, Judge Hoskin, for the record. Mine is more grammatical, Senator, the way that you've got it written, and I know it wasn't the intent, but certainly I think it can be read because of the way that you've got it put in place. If such compensation is not nominal, comma, recurring, which could be interpreted as not nominal and not recurring. So my suggestion is that you put is not nominal, comma, is recurring, and then go on from there. That way there's no question as to whether it was the positive or the negative on that second with regard to that. From a global standpoint, I think I put my position with regard to this on the record when we were discussing it last time. I've had no problem calling bonuses salary and wages. But if you're running into problems, again, my only concern is unintended consequences.
Sure. And when you said that, I thought maybe just moving recurring ahead of not nominal. That way we don't have to add a word. I know LCB is always getting after me for being wordy, so I'm learning.
Yeah, it was just my concern that it could be read as not
Sure.
modifying both of those. So that's all.
Sure. Judge Rob?
The only question I have is with the recurring language. And when I think about it, people now are getting signing bonuses and it is becoming routine. That is a one-off, but sometimes that is a big whack of money. If you get a $10,000 signing bonus, but it's not recurring, shouldn't that be something that can be looked at as far as that year's child support?
Well, Keith Picker for the record, I hesitate doing that. And even though I just had a case, in fact, where we got a major signing bonus, I was on the other side of that and I couldn't, I mean, we make arguments for our clients, but in my own mind, my thought is we can't review child support for 3 years. So do we then take that and divide it by 3 so that at least it's not going past the point, or it's not ending before the expiration of the period where they can't make the adjustment? I think if it's not recurring, that might go more to alimony, which is an interesting position for me to take since that's why this came up in the first place. But or, you know, it was the judge's comment that bonuses are a discussion for alimony, which I'd never heard before. But I really do think if it's not recurring, we shouldn't be including it because it's a snapshot in time and it's got to last for 3 years. But that's, you know, I'm eager to see. Karen Cliff looks like she's chopping at the bit. So love to
not
get
everybody's married and alimony's not on the table for everybody. There's a lot of custody cases.
This is Karen Cliff. Is there any concern about the not nominal language opening up a host of litigation? How do we define not nominal? You know, there's a wide variety of job classifications that award bonuses. I think when we have a separate section that relates to bonuses, we're suddenly taking it out of, I think, what Judge Hoskin was referring to. We've always included bonuses, or at least left it up to the hearing masters, the judicial officers to do so. So by separating it out, we're now really sort of confining the definition of bonuses to reoccurring, not nominal, and we've taken away that discretion from the judges to make that determination. So I don't know. We're limiting it, and I think we're opening up the not nominal litigation. That would just be my thought.
Judge Rob.
Madam Chair, and this is Bridget Robb for the record. Judge Hoskin, if I recall correctly, said, why don't we just say bonuses and treat it in the same way in income? We've included it so that everybody knows that a bonus is income. And quite frankly, I don't think we need a statute to tell us that the sky is blue, but apparently we do in this particular case. And so we would include bonuses, but let's leave some discretion to be able to deal with those things.
I want to make a motion that the sky is blue.
Passed.
What if under
go ahead.
Under salary and wages, it was salary, wages, or other additional monetary compensation? Is the issue that salary and wages are the 2 words that the judges are hanging their hats on? Or do we just take out that and say any money obtained? I mean, where do we go with this? So that it doesn't have to come in the form of a salary. It doesn't have to come in the form of wages, right? I don't know how to get the point across. I don't feel like this was an issue before, and I don't feel like our new stuff is that far off from how we practiced before on what gross income was, right? So why is it an issue now?
Right. And Keith Pickard, for the record, my thought was, well, and it's interesting, we've come full circle, because if you'll recall, that's exactly what I did in the first iteration. I said salary, wages, including without limitation, bonuses, money earned from overtime. And then there was some concern about the following language. So it's bonuses, which is substantial, consistent, and can be accurately determined. And we said, no, those aren't really good words to be using with bonuses. And so that's why we separated it out. I'm completely okay with the idea of inserting it in A, because I personally think that, again, it's not nominal. Well, then it's substantial. It's recurring, so it's consistent and can be accurately determined. So I'm okay with that, but it's because we have half of the new judges that we have down in the South have no family law experience. And so they're trying to get up to speed on the law. And we're seeing them asking these questions, although interestingly enough, this issue came from someone who practiced for 15 years before going on the bench. But the comment was, well, you didn't specify bonuses, so that's going to be a discussion for alimony.
Do they not understand statutory construction? Because it says at the very beginning, without limitation.
Right.
That should control everything. This is not an exhaustive list.
That was exactly my argument. And so, and then having another judge, one of the new judges, I should say one of the new judges who didn't practice family law, asked that question. And I think it was, part a little bit of a needle stick, and partly because, they wanted to know, hey, what are we doing with bonuses? Are these really supposed to be included? And of course I said yes, but there is some need, I think, for clarification because it's come up. And, as I say, I'm completely okay with adding language to sub A saying bonuses, money earned from overtime, and even to the chair's point to say any other income. I mean, if you remember back before we pulled it out and pulled this into the regulations, we used the term any source, income from any source.
Source, yeah. Maybe that's part of the issue. We're not using that language anymore. It used to be okay.
Yeah, but then that was over-inclusive, right? And so, but this process is helpful. I'm okay with either, but I do think because, where this is certainly repeatable, I would suggest we make this a little clearer than it already is to just resolve this issue.
Just a quick comment, Joe Sanford, for the record. Is there, since we've discussed salary and wages as compared to income from any source, is there potentially a solution more towards employment pursuant to or compensation pursuant to employment, or something like that, instead of salary and wages, which is designed to be more inclusive than I understand I understand in the loose term the idea of a judge who would say, well, salary and wages to me is very clear on what that is. That's salary and wages. And bonuses, I understand the argument that they are not part of salary and wages. Being on the committee, obviously, I understand that was not the intention, but I do understand the argument. I'm concerned with if we put work overtime and then bonuses and then other things like that, it's going to start to seem like this is the list. And if it's not on this list, then it's not meant to be included. And frequently we deal with like base personnel out here in Fallon. And so base housing is a type of benefit that comes up all the time. And I don't know that I would count that as a bonus, but we include it right now. And so I'm just concerned that we'll never be able to get an exhaustive list of all the different forms of compensation that can exist, whether it's, housing bonuses, or whether maybe they don't call it a bonus, like I think in ours, it's housing supplement, whatever they want to call it, from different groups. And so is it maybe preferable to change salary and wages instead of trying to make a bigger list?
That's kind of where I was going with it, where it changed. I like the word monetary compensation because I feel like it's very broad and covers a lot of things. And maybe replace the words salary and wages with monetary compensation. Is that broader because it's not a salary check? It's not wage, wherever you get it from, it's a form of compensation. I don't know.
And Bridget, Rob, for the record, that would include, because it occurred to me, if bonuses aren't in here, then what are we doing with commissions? Because that's not salary, and that's not strictly wages either. So I like Madam Chair's suggestion.
Keith Pickard for the record. I do too. I would like to, for purposes of consistency in practice, suggest that we move, or we start out with monetary compensation incident to employment or something to that effect, including without limitation, salary, wages, bonus, money earned from overtime. So we're allowing the practitioners to see that we're not trying to make a wholesale change to what we're defining, but it's still including without limitation. Does that make sense? I don't know if that's necessary, but I know as we're trying to adjust the statutory schemes generally, one of the things we hear from LCB Legal on a fairly regular basis is you don't want to change, if you're not changing the intent, don't change the language completely, because that's going to throw people off. And so I'm just sharing the thought that comes to mind.
Additional comments? What, Senator Pickard, can you say the first part again? You said monetary compensation. Did you added something before the including?
Yeah, it was what Joe Sanford said, where we're talking about compensation connected to, or I said incident to employment, because that's what this is talking about.
Yeah.
This is Karen Cliff from Clark. I'm a little bit concerned about tying it into employment. We know there are beneficiaries for other reasons, trusts, and I was just kind of going through here, and I see that we have annuity or something of this nature, but there are people that off of their means. I don't know if it's a salary, but it's definitely wages, that it's not attached to employment. So sometimes I'm concerned about the specificity. I like Kim's idea of just monetary compensation instead of tying it into employment. It's just broad.
It is broad. It started capturing a lot of things in my head. It's like, oh, I could fit that in there. And it's not to get away with things. It's that is the intent. It's right. Capture that income.
My hesitation, Keith Pickard for the record, my hesitation is only that I get nervous when we're getting really broad. I want to make sure that we're not under-inclusive, but at the same time, not over-inclusive. So let me just, suggest a brief discussion. Is there anything that would come under compensation, monetary compensation, that wouldn't fall under the intent here?
I'm looking at the language right now of the present regulation, and it makes sense to keep it the same way it is with this change, I think. First of all, it says gross income includes without limitation, and then it goes through the laundry list of various things that gross income is. We are really just talking about sub A, which is money that comes from working. And so I think we should say monetary contribution or monetary compensation incident to employment or whatever appropriate language there is, and then including the salary wages. That way, I think we've captured everything, but it is discreetly in that sub A, because that's really what we're talking about. If we use it right there at 1, we then have we have a problem with understanding how all the rest of the subparts come in, because they aren't necessarily incident to employment.
All right, let me suggest this, Keith Picker for the record. Let me create that in a new one. Let's table this for the rest of today, because I don't want this to consume much more of the meeting that it already has. Let me come back with a new iteration, and let's revisit this next meeting.
Okay. Any additional comments on that before we move on? All right, sounds good. So before we jump into the AAML changes, let's talk about agenda item number 25. Just to prime everybody on a new issue that came up also from one of the new judges in the South. Assemblywoman Cohen fielded this question, and when she and I looked at the actual statutes, we realized what the issue is for a new judge. Let me find my exhibit. So it was labeled Committee Exhibit Surratt 425. I can't read it. Oh, 160 versus NRS. So if you look at what we did in the NACs, we were clear when we said when the child reaches 18 years of age, or if the child is still in high school, when the child graduates from high school or reaches 19 years of age, comma, whichever comes first. And that, of course, well, I wouldn't say of course, but from a private practitioner perspective, that is the way it's been applied and how we have utilized it, even under the NRSs. But if you take a cold hard reading of NRS 125C.0045, it says otherwise when the child reaches 19 years of age. So if the child turns 19 and or say graduates from high school, and the issue was with Assemblywoman Cohen and with this judge was, does it go all the way until the child reaches the age of 19, or not, the whichever comes first? Are you reading what I'm reading here?
Keith
So
Picker for the record. Yes, and it's interesting. I don't know. Maybe I'm probably to blame for the language of NAC 160, because this is how I used to say it, and then it was pointed out to me that no, it's the earlier, reaches 18 or the earlier of high school graduation or turning 19, and so I've modified how I describe it to the latter. And now when I see this in 160, I'm thinking, crap, that's how I used to say it. And so I probably was the one that suggested that, but she's right. It's when the child reaches 18 years of age, if the child is no longer enrolled in high school, otherwise the earlier of graduation or 19.
And I'll say,
So,
Leslie Cohen, for the record,
yeah.
I'll say that I think under the NAC, that was always the intent, right? That language is what was always the intent. And because when the chair and I were talking about this, I was saying, no, I know the language is in the statute. I know the language is somewhere. And we were going through the statute. And then because I said, I know I read this language all the time. And then I realized, oh no, that's just the way most of us practitioners draft our decrees and our orders, using the length for years before there was a 425. We were basically drafting that language into our orders because that's what makes sense. I think that was the intent of NRS, and it's just not necessarily well drafted. And this judge happened to be, caught it, but it was never an issue before 425. And I think it was something where we were all just doing what was the intent and what was right, but technically it's not right.
So instead of on graduation, the judge is reading that it goes all the way until 19 instead of whichever comes first on the graduation part of it, right? And so I guess the bigger issue I have is when it never occurred to me that we had different language than what was in the NRS, in our NAC on this matter. And this first time it's come up, and I'm not real sure what to do with it because we are in conflict with the NRSs but I think our language is better in the NAC. And so I suppose that I don't know whether, it would be a statutory change for NRS to clean up NRS, or we change ours to match the NRS. I don't think we should, but we definitely are very well aware of the conflict between the two. And I don't know that. And when I went back to the original bill and I tried to figure out our authority on this, I know where we thought we had the authority. We went around in circles about our authority on the modification language, right? And on the emancipation language. And there's one little section that caused us to want to clarify this. And I don't think we thought twice about it because we thought we were just clarifying, making it a little more clear than what was in NRS, but the fact is they actually conflict now. And so I think our hands are tied maybe on this. I don't know until we can get to the ledge and make a change to NRS.
Can we make a recommendation? I'm sorry, Judge Hoskin, go ahead.
No, I don't see the conflict, because if they're graduating from high school, and they're no longer enrolled in high school. I don't know that we're in conflict. I can read it that way, and that's the way that I've read it for more years than I care to admit. But I don't know that it's. You can, if you take a very specific reading of it, I see where that judge may have been coming from, but reaches 18-year age if the child is no longer enrolled in high school. Well, then we're done. Then that occurred first, even under the 0045 language, and just an offer to maybe ease everybody's mind.
This is Joe Sanford for the record. I agree with Judge Hoskin. I understand the plausible reading that's being read by this judge. That I guess I would say that I would find the statute ambiguous. I didn't before, but now that it's brought to me, I can see the ambiguity. But I agree. I think it's an ambiguity. I don't believe that it's a clear reading where there's only the one plausible reading. And because it's ambiguous, I think that our regulation is better in clarifying that ambiguity than is
language.
That would be my interpretation. Otherwise, I think you end up in a situation where, it depends on, I think the reading that's being read by this one judge is incredibly literal on the language, but the way it's always been read is also a reading under the language that makes sense. And so I would say it's more ambiguous than I thought it was, but I would still say ambiguous, and therefore ours is not in conflict. It's just going in one.
Clarifying. And as a reminder to committee members that have their cameras off, the Attorney General's office requires them to have them on for the meeting.
Keith Picker for the record. I agree completely with Joe on that. When I first saw this and when I said that Leslie was right, I think she is, because it reminds me of the oral arguments that I made on the legislative continuance statute when we were arguing that NRS 1310 allowed attorney legislators to put their cases on hold. The justices were asking questions like, well, you know, we can't read things into the language. Doesn't the black letter law, doesn't the language say, and they would quote it, right? And I'm thinking, well, we're facing the same kind of situation. I agree, it's an ambiguity, but it is a reasonable reading. As you know, overly literal as it might be, it's still a reasonable reading, but it is an ambiguity. So I don't think we are in conflict per se, but I do think that we should do a statutory change to make it clear at the statutory level. But that's something you and I will have to work on separately. In fact, maybe we can get Ms. Cohen to use one of her precious bills for that.
Good Judge Rob.
Is it possible, and Senator Pickard, I do not want to overstep, but would it be possible for this committee to make a recommendation that the statutory language be changed to be consistent and clarified?
Absolutely. And I think that would, Keith Pickard for the record, I think that would make it something that then the Judiciary Committee would be able to take on. And we've got people here that have good conversations with the chairs of both of those committees. So I think that can be done. Statutorily speaking, we didn't empower the committee to we didn't give us any bill draft requests, but as a statutory committee, we are certainly capable of making recommendations for statutory changes.
If I may, Leslie Cohen for the record, I would just suggest that we see if we can get it, if we are interested in having a statutory change, which does kind of scare me. I don't want to open up the statute, but maybe in order to keep it as tight as possible, if we could have it go through the interim committee and have it put on the agenda for the interim committee and the interim judiciary. And that way they can make the recommendation in the next legislative session and hopefully keep it as concise and pared down as possible. Because it does concern me, because I do think it's something we should address. The judge who had raised it as an issue to me is someone who had been practicing for quite some time before. So it wasn't one of the judges who had never practiced family law before, was an actual practitioner and still was concerned enough to raise it as an issue to this committee. So I'll just leave it at that.
Okay. Well, at that point, I believe we're outside the scope of this committee's ability to do anything beyond this, but we do have individual members, including myself, that can work on possibly getting that to the interim committee and see if we can clean up that language, at least get it to match. I think what was good that came out of this is that, and correct me if I'm wrong, committee, that we believe the language in the NAC is clear, has better language, is a little more clear.
Yeah.
Okay. Amazing what you find over time that you weren't expecting. Okay, so now let's start our AAML conversation.
Madam Chair, were we going to talk about alimony?
Yes, we could go back to alimony right now. So agenda item number 5. Discussion and recommendations, clarification of NAC 425.025, 1M, the inclusion of alimony and gross income in the regulations versus NAC 425.0252 that does not include or deduct alimony paid from the obligor's income. Committee comments? You're on the hook, Judge Rob. You put us back there.
I blame it all on me. I would simply say this. Alimony is like anything else. It's money in your pocket if you are the recipient. And you also, at this point, don't pay tax on it. Whereas the party paying alimony gets hit with the tax and then right now is not able to deduct. That to me is not equitable. And if we're really looking at right sizing a child support amount, this to me is different than saying pre-tax, because you aren't gaming anything. You know exactly what this number is. It's a number that's been set by the court. It's a number you have to pay if you are the child support payor. And so I think that alimony, I have always included alimony because I believe it to be income. But I think that alimony that's being paid should be deducted from gross income before we do the calculation.
This is Karen Cliff, and just to be clear, when you say alimony paid, you do mean to the obligee in that particular case.
I mean, if you are, I used poor language, I apologize. If you are the recipient of alimony, that should be included in income. If you are paying alimony, that amount should be deducted.
Right, but paying it to the petitioner in that particular case, or paying alimony in general?
I think paying alimony in general. It
So
is not money that ever goes into your pocket and legally has to be paid to somebody else that you're in addition getting dinged with taxes for.
Okay, so this is a really big change that I think requires a lot of discussion, right? Because that petitioner, that custodial parent in that case is not benefiting from the alimony. I understand what you're saying. I just think it's a bigger discussion.
But I don't think it's a binary thing. What I am looking at is what someone has and what somebody actually has in their pocket to pay. And the
Ability to pay.
Exactly.
Right, but how do we know they're actually paying it? They might be court ordered to pay alimony to a certain custodial parent, because we're considering the custodial parent in this case, and we're using the language received, alimony received. But how do we know if we're willing to give that deduction from that obligor as having an alimony order? Let's say it's an out-of-state, he or she needs to pay alimony. How do we know they're actually paying it? They're getting the benefit of a potential deduction, but there's no accountability in terms of payment. When does that alimony award end? It just opens up a can of worms I think we need to consider.
And I agree with you. Again, Bridget Robb for the record, I agree with you, Ms. Cliff. I just think that we do open-ended things all the time. If we're going to nail this down to only things that we know and can track, I think we're going to end up with an inequitable result for the people paying child support. And believe me, that is not something you're going to hear me say very often.
Yeah, for me, it's more than the tracking piece. There's a fairness piece to me attached to it. And I'm all about ability to pay, but I need to consider this more.
Kathleen Baker for the record. I think it also opens up, if you're talking about a legal obligation to pay alimony, then what do we do with those legal obligations to pay child support in other cases? Do those get deducted from the income?
Well, we haven't discussed serial parenting has been pushed off from day one and has not made it back on the agenda because no one has known what to do with it. But that was going through my head too, that it's almost the same conversation.
And Kathleen Baker again, the other thing is, what if they're ordered to court pay restitution, or they have other court ordered obligations? I mean, where do you draw the line on when it's a court ordered obligation and it comes out of their pocket and they have no control over it? I think
I draw the line, quite frankly, I didn't say court ordered obligations. I said alimony. I draw the line at alimony. If they have to pay restitution, that's on them. Their children didn't commit the act that required the restitution. That's on the person making the payment. And you get no grace from me for that. But this is a different issue.
Leslie Cohen, but why is alimony different than your other obligations that are coming out of your pocket? I get what you're saying. This is the line I draw, and that we're not talking about everything, but I don't understand why it's different than everything else.
I think for me, it is different because it is quantifiable. You know exactly what it is, as opposed to the conversation that we had at the very beginning of the inception of this committee about taxes, for example, which are the payor parent, the obligor, can manipulate taxes in a way that would decrease the amount of the child support. That kind of manipulation is not something that can happen with regard to the alimony, save and except whether someone pays or not. And quite frankly, if they're not paying, then that's something that the court can look at. I routinely make reductions in child support amounts to account for the obligor having to travel to exercise their parenting time with a child. But if they aren't traveling, that is subject to being, the child support amount is subject to being changed because they aren't making use of the benefit of what that reduction was supposed to be for. And I think on a one-to-one basis, we can look at that. But as an overall issue, I simply don't think it's fair to have somebody who's paying alimony many times to the person who is receiving the child support and not be able to back that out.
Leslie Cohen, I think I'd have to think this through, because to me, when I think about it, if you've got two families with the parent making the same amount of money, but one pays alimony to an ex-spouse and one doesn't, the child is then receiving a different amount of child support. So in effect, the child is paying for their parents' alimony obligation, and that seems kind of odd to me. So yeah, I think I definitely need to think this one through more.
I will add commentary that the word alimony made it into 425.025 after our committee's work. It was done through the DWSS side of things. So we never did have a really good, healthy conversation on this as a committee. And it immediately ruffled feathers within the private bar. There were immediate conversations about it being placed in one spot and not the other. I guess what I want to know from those that are trying to think through this, if when we clarified, you know, alimony paid anywhere versus if it's paid to this obligor that this case is about, does that change your opinions, the ones that are struggling with this? Because obviously that person's already receiving alimony from the same person and then also receiving child support, and that alimony was calculated into the child support. To me, that's a problem. And is the problem, for me, or what I'm trying to assess with the committee is the problem the difference between that or just ever including alimony? Being this obligor versus outside obligors. Outside, I don't know what other word to use. I'm using outside, but.
Let me sort of tell you, and I don't know if it's going to help, but as I'm trying to process through this, my gut tells me initially I'm more comfortable with the alimony that's being paid to the person that's also receiving the child support, because I can control both of those and I can analyze both of those to come up with a right size support award on both sides of it. When it's out of my control and it's an obligation to somebody else that I have no control over, I have a reaction that I'm not comfortable with doing in that way. My problem currently is that I can't rectify those two, because I understand Judge Rob's argument that it is what it is. And I'm trying to sort through, is it my reaction to the inability to control all of those pieces, similar to the serial parenting and another child support obligation with regard to that? So I agree with Ms. Cohen. I don't know that I'm ready to wrap my head completely around this issue, but I do understand the arguments. I tend to lean towards one because it feels more comfortable, and I don't know if that's the best way for me to lean at this stage. So I'm not ready to resolve it, I guess, is the easy answer to the question. I would like some time to think about it.
And I'd like to add, Keith Pickard for the record, another layer or lens on this. And that is, if we step back a little bit and remember that child support is based on the gross income, alimony is based loosely on the net income, because we talk about reasonable and necessary expenses. And so we're looking, and we calculated, and this is where Joe Sanford, I think, had an oversized impact on the first iteration, where, as I recall, Joe, you were the one who kind of dove into the basics of the percentages and how we came up with the. I'm drawing I'm drawing a blank on the language, but what were the minimum requirements for the kid, the basic needs, right? And so we were basing our percentages on the gross income. If we now start deducting things initially, at the first part from the gross income, does that now throw off the percentages? Because ultimately, the percentages were chosen to fall within the spread, right, within the high and low bars of the curve. And so what comes to my mind is, I don't want to upset the calculations and all the work that went into coming up with those percentages of the tiered or the tiered percentages of income. I would rather leave the income paid as a deviation, move that down to the ability to pay question the adjustments that we make, and ability to pay is one of them. But I'm really hesitant to start deducting the alimony from the gross income, because then, particularly as we get into legislative intent and the record of the discussion, I think it's a very small step to say, well, what about other reasonable and necessary expenses? Does it have to be court ordered, or what about contractual obligations? I have to pay a mortgage. Do I get to deduct that from I'm required to pay it or I lose my home, and so ultimately that hurts the child. Do I get to deduct that from my gross income? And so I think it puts us on that slippery slope to moving child support to a net income question. And of course, that's never been the intent. And then, it opens the door to the discussion again about moving over to an income shares, because that's another small step if we're going down that slope. So I'm really hesitant to open the door to deducting alimony from gross income. And I think that I don't see Marshall on, but maybe he is. Maybe that goes to the AAML piece where they specified alimony received as part of that gross income to clarify that. But I thought I would throw that layer on because I think it's important that we not lose sight that the percentages, the tiered percentages we came up with were based on gross income, and alimony is yet another necessary, but it's a post-income expense, and I hesitate doing that.
Judge Rob?
I understand the discomfort that Judge Hoskin is having, and I have some of that same discomfort. And I understand Ms. Cliff's saying that there is no indication that that alimony that's paid to a third party who isn't part of the child support action is anything that you could say with real specificity, or you could say definitively. has been paid. But the fairness question for me, and this is not a hill I'm going to die on, but it is something that I think we really need to talk about and mull this over. And I'm happy to come back and do this on additional agendas. But especially when it's the two parties that are involved in the child support calculation, that seems inherently inequitable to me. And it's that inequitable piece when a payor gets a child support order that they don't think is fair, that's when we have problems collecting that child support. And so I just want to make sure that we're doing everything we can to be balanced, to be as fair as possible to both sides of the equation, and to make sure that one side doesn't feel like they've been taken advantage of in a way that is going to keep them from or be a barrier to them paying the child support they should be paying.
This is Karen Cliff, and Judge Rob, I appreciate your sentiments. My concern with the fairness argument is the alimony that could potentially be paid outside of the family unit that the court is looking at. My concern is the fairness in this particular case to the children in this particular case, and maybe the fairness and the equity that we're trying to resolve is getting that non-custodial parent or that respondent, obligor, however we want to define it, to go back to that case and address the alimony in that case. And since their circumstances have changed and they now have a child to support or children to support, that they revisit the alimony in that case and perhaps review whether a reduction should happen in the alimony given this family. But I don't necessarily know that this particular family should have to navigate the alimony that's unrelated to this case.
Well, and those may be two very distinct. I'm getting feedback.
Yeah, you are.
Those may be two very distinct circumstances. And we may need to take a look at, again, the serial parenting versus just this unit.
This is Joe Sanford for the record. I guess I'd like to start with, I tend to agree on the fairness aspect with Judge Rob. I completely understand, and I just at a gut level agree that there's a certain level of unfairness, and just unfairness at the viewpoint of the person who's going to be paying when they consider, okay, I have an order, an obligation to pay this alimony. You know, as the judge who just ordered this, that I'm not going to have that money, and now you're still saying, well, I didn't count it in my child support, and I completely agree on that. I would say I have the same concerns with Ms. Cliff that there's some ability on the proof level that can be quite difficult. I would also say there may be some difference in feelings between the district courts where they have the ability to control the alimony and the child support. In our program, we will never have the ability to address the alimony. And so it will always be similar to the cases that you're saying you have a concern with, Judge Hoskin, which was that you're not going to have the ability in any of the 4D program courts to say, well, we can address the alimony because we just won't. And so every case will have that concern, which is going to be, okay, well, we can't address this alimony, and so how do we want to do child support? Can you pay? I guess I'm open to future conversations. I think it's actually probably something that I hadn't put as much thought into as is probably worth in this case. It, to me, on a fundamental level, makes much more sense in a case where you're talking about one family unit where you have alimony and child support together in one case. You know how much that support is going to be. And just as a whole, serial parenting is probably my most significant issue that actually needs to be addressed as this committee goes forward. is incredibly, incredibly common in our cases, and is probably the biggest variant in between different cases on how it's handled day to day. Is, you know, it can change pretty significantly. And so I think that this probably is best addressed along with that aspect together, because if we were talking single family units, I don't think that there's, or at least I don't have a concern at all in it with the single family unit. But when we come to the serial parenting concerns, especially those, I mean, fortunately, those tend not to have alimony, right? Because serial parenting is sort of goes hand in hand with not having a long-term relationship that, you know, has that is the basis for alimony. But and so I don't see it that often, but I think maybe if we address them together, it may help address some of the concerns that the committee has.
And from my comments, I've been holding off on putting serial parenting back on the agenda until I had some kind of word from somebody that they had an idea to discuss on how to address it, versus always just saying it's a problem and we need to fix it. But if we're ready, I can put it back on the agenda. No one's been ready with an idea. So I didn't want us spinning our wheels on it.
Madam Chair, Judge Hoskin, we tasked somebody with looking at other states and seeing if somebody else had that? Am I recalling that correctly?
Yeah, but I don't remember who.
Nobody's going to volunteer.
We haven't touched that topic in a long time now. So it's been so long that I don't
had
remember.
a recollection that somebody was going to look to other states and see if they've done it, and perhaps at least give us a starting point.
I'm happy to look at Wisconsin. I know we kind of based our guidelines on that. They have a new set of guidelines. I'm happy to look there. If there's any other states you identify, I'm happy to look.
Yeah, we did receive, or DWSS forwarded to me also, the new guidelines that Wisconsin passed. I haven't looked at them, but if anybody else is interested in seeing them, I can forward the same email. It's just a link to their new guidelines. And they were a basis of a lot of our changes. So I appreciate that, Ms. Cliff, and I will put you down for that. What I'm hearing, unless I'm wrong, we want to simmer on alimony for a little bit longer, keep it on the agenda, and move on for today. Okay. Head shaking. So for the record, I've got yes heads. So let's move on to agenda item number 10. And for this, we'll need to start pulling up the recommended changes from AAML. And so agenda item number 10 is discussion and recommendations on AAML recommended changes to NAC 425.025, sub 1, and I think that's under the alimony, isn't it? Well, they've got another edit in there. So under sub 1, they have a K to add the word to or access to the earnings instead of just access the earnings. And then also under alimony, they changed the word to actually alimony received. So it's not really the discussion we were just having on alimony. It is slightly different. It's just clarifying the word alimony in this section under M that's already existent there. Any comments on these two changes, proposed changes? Anybody want to make a motion to adopt these changes?
I will make a motion. This is Karen Cliff to adopt the changes.
Okay, and do I have a second?
Kathleen Baker, I'll second.
Okay. Any further discussion?
Yeah, let me clarify. Can you repeat again what we're specifically adopting?
Yes, so they have under NAC 425.025, subsection 1K, They have added the word after the word access, they added the word to. So it says undistributed income of a business entity in which a party has an ownership interest sufficient to individually exercise control over or access to the earnings instead of just access the earnings. Typo, really. And then under subsection M in that same section, where it had alimony period, they have changed it to alimony received period.
All right, Keith Picker for the record. I think because we're going to be holding over the discussion on alimony, would it make sense to kind of hold back on M because we might be altering that yet again if we decide to do something with alimony, or are we comfortable focusing on the alimony received for now? That was my hiccup.
Judge Rob, you had
Judge
Oscar.
Go ahead, Judge Rob. No, go ahead, Judge Rob.
Oh, the only thing I was going to say is, so I'm fine with adopting this as a clarifier for now, so long as it doesn't foreclose our future discussion on the greater alimony issue.
Judge Hoskin.
The comment I was going to make is I thought we were pretty much in agreement, although we certainly didn't take a vote, that alimony received was the intent of well, it wasn't really our intent. It was kind of stuck in after the fact, but I don't think we had a problem with that. The other thing I was going to raise, at least on my version, it looks like there's a few other changes, but they're just adding commas, at least from what I can tell, in a few other sections. So I just want to make sure that that's part of the motion.
Yeah, 1A and 1D.
And those are
have
removing
commas. That was the
I
next
typically
point I was
don't put
raise.
a comma before an and, but I know some people do, so I don't have a problem with it, but okay.
I am a firm believer in the Oxford comma.
Well, and there are important court cases on the Oxford comma. I just want to make sure
indeed.
we know what we're doing.
Okay, so for clarification on this motion, it's to adopt the AAML edits. And under 1A, after the word consistent, they added a comma. And under 1D, after the word plan, they added a comma.
Just
Ms. Baker and Ms. Cliff, yeah?
Maybe I'm mistaken, but in my understanding is they are deleting those commas. At least that's the way I read it. It's underlined with a strike through.
Are they?
Comma. So I believe their recommendation is to delete.
I need to put the actual next to it because I can't read it well enough. It's so small. Let me look.
I do believe Mr. Sanford is correct. It does look like a strike through, and I don't want to. And again, I'm a strong believer in the Oxford comma, because if you don't have it, it can be interpreted to be part of the same clause, and they are intentionally separate. So I would rather keep those commas in there.
Well, hold on, Judge Hoskin. Again, I'm looking at the master that was provided, and there's no comma after consistent in the master. So it looks like perhaps they want to add it. And after retirement plan.
No, you're right. I just pulled up the language from the NAC, and we were right the first time. Sorry, Joe. I was standing behind you.
I was only looking at the red line, and the red line.
I think it double underlined the comma when they added it. And so that double underline makes it look like a strike through. That's the confusion. But yes, I'm in the original NACS online, and there are no commas. Okay, so the question is for Ms. Cliff and Ms. Baker on your first and your second, do you want to also add in those commas?
Yes, motion to include the Oxford comma.
Okay.
Kathleen Baker, motion seconded.
All right, any further discussion now? Okay, all in favor, state aye.
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 I,
Opposed, state nay. Any abstentions? Okay, motion passes.
And Karen is now my favorite person on the committee today.
Likewise.
All right. I knew this was going to be painful. We can get through this, though. All right. Agenda item number 11, discussion and recommendations on AAML, recommended changes to create a new NAC 425.100. And so really what they have done, well, they deleted the 100 because what they've done is they've kind of reorganized, and I think they were trying to create it as a 425 without the 100. I don't think that Ledge would do that exactly. But the current 100, the language, they have edits in here to it. And so it would, I think, still have to stay as 100, to be clear. They deleted a lot of that language. They've moved it down, so it's not necessarily gone in this part of this very difficult way of doing this agenda. And they have added some new language as the starter language. Any comments on this part of it?
Keith Pickard for the record. First, I would say I don't know that we need to worry about the numbering. LCB and DWSS will work that out. And I do like some of the organizational changes they've made because by putting it in order, I think it'll make it a little easier to walk through. But I personally, I struggled with this first section, not so much the removal of the language and moving it, but where they've added the red at 3B, it seems really clunky to me, where it's shall do so, which is language we try to stay away from if we can, after any other alimony or other payments, comma, then calculating, then making adjustments, and then allocating medical support. That's a very difficult read for me. If we're trying to institute an order, then we do as we've done elsewhere in the statutes. We create the order by enumerating it, right? You say in the following order, colon, 1, this step, 2, this step, 3, this step. There's a better way, in my view, of creating a cascade effect, if you will, an order of operation than this. So, but of course, then we have to agree first on, is this the right order? And I'm not sure that we want alimony to be right up front like that, but maybe we do. So I have two problems. Number one, the way they've done it. Number two, the order that they've done things. But, you know, maybe it's right.
I'm confused by it, I have to be honest, because it says a court determining a child support obligation shall do so after any other alimony or other payments. What does that mean? Because that's not really what our process is, right? I mean, we were just discussing that with the alimony conversation. It's, you know, we're not, and then calculating the guideline schedule obligation. Well, that kind of skips that. Our prior statute that's about determine gross income, right? The next step after determining gross income isn't really determining child support after any other alimony or other payments. Why does it come after? I don't know. I don't understand what this language is or why it's there, or how it's written personally. But any other comments from the committee?
This is Joe Sanford for the record. I understand what they're attempting to do, and I think they put it in their notes that I think the entire intention of this is to create an order in which the court is supposed to calculate child support.
Right.
That being said, I have some very significant concerns over putting anything in here that says shall do so after alimony or other payments. One, I don't know if we have any jurisdiction to make that. You know, I'm maybe a judge somewhere might have a different opinion about that, but I can't imagine telling my court that, well, you're going to do it in this order just because child support said so. Second, I agree with Senator Pickard that I think there's a better method of doing this. And I think we had tried to do it originally, which was, you know, calling things like base schedule and then adding things to the base. And I think that creates the order itself without having to have a statute that's, or a guide, an NAC that's going to say, do this, then this, then this. Especially since I think it potentially builds in errors that aren't even actually errors, because, you know, say somehow you end up with, you know, the right number, but it wasn't done in the right order, and now we have concerns about things like that. And so my preference would be, if the intention is just to create an order, I think the better method is, and it may be part of what they had already suggested with creating better defined terms for what we want to say is the base support, what that means, what base support plus childcare plus medical support means, whether adjustments come after that addition or before. I completely understand the concerns in how they want that to be done. I think there's a better method than doing something that's going to be very hard and specific, like shall do type language here.
Any comments on the deletions of language from here? I think that their replacement paragraph isn't clean, and we're kind of discussing that right now. But I know they moved that language down, and the removal of it from the very beginning of the statutes, any issues with that? I think it needs a different. You're right. I just have to go back to when I think about our original master document. We had done this really neat, nifty thing where it's, you know, step 1 and step 2, and then LCB doesn't like step 1 and step 2. That doesn't work for statutory structure. I get that, but I guess we're looking for a whole nother alternative means in between what we did originally, what AML is doing here, and something completely different to get that order and structure in place. I know what they were trying to do. They're trying to put an intro paragraph that says this is the order you're going to go through, because we can't put the word step 1, step 2, step 3 in there, right? So I know what they were trying to do. I just don't, for statutory structure purposes, it's not working. But Judge Hoskin?
Oh, yeah, I was just going to say that I've got, and it's probably the way that my brain works, I have a hard time with, oh, well, this is all gone, but hey, we're going to put it back in over here, but I'm not sure that putting it back in over there accomplishes what we were trying to do initially in 100. So I was trying to keep quiet until I saw it in a final form so that I could wrap my head around it. But your comments elicited that there may be some concerns with regard to that. So I don't know that I'm ready, at least at this point, to say, yeah, let's dump all of that in the hopes that we're going to recreate it down the road.
Okay. Unless I'm wrong and somebody else wants to discuss this section more, why don't we move on to some of the other edits and keep going through this a little bit, and we're just kind of skipping that change for right now. Because I think if anything, what it does, to be clear on how we're going through this, I mean, we're reviewing what AML provided. So if we're not going to adopt that, doesn't mean we can't adopt something different as the new intro at the beginning, right, to replace 100. Okay.
Well, Madam Chair, yeah. If I can just interject on that thought, Keith Pickard for the record. I think it's wise to do exactly what you suggested, that we go through and talk about the different things, the things we like and the things we don't. I would like the AAML to take our comments. I don't see anybody on the list of attendees from the AAML. which is unfortunate since this is theirs. And maybe I just don't know who all is members of the
There's a phone
AML
number.
and
Yeah.
you know, who might, but anyway, I would hope that they would be willing to come back and work with our comments and make changes to their proposal. But there are some things that I think do make some sense that we could do without doing damage to the work we've already done. Order is important, and I think that their comments, all I mean to say is that their comments raise some issues that I don't think I had considered before in terms of the order of operation and how we structured the prior things. So, for example, we put childcare ahead of the actual calculation. So moving that down below and making it more of a stair step kind of thing does make some sense to me. But where they've changed, and I agree with you, changing or deleting 125-100 has a substantive effect. Moving it down, or maybe it was Judge Hoskin that said, you know, moving it down and changing the language, that even though slightly, does change the substance of what we're doing. And so I agree that we need to be careful, but I think the AAML needs to come in and work with us since this is their document.
Right. This is Karen Cliff. There's 16 potential agenda items as it relates to, you know, their proposals. And for me, out of respect for not just, you know, where they're coming from, their areas of expertise, but also for how much time and effort they've put into their review and their proposal, my preference would be that they are on the agenda as presenters to put their proposals up on Teams, explain their basis for these changes, because they're not here to really explain it in isolation. We're looking at these 16 individual items and trying to presume why they maybe, you know, are requesting some of these changes. But just out of respect for them, and I think to really make a well-informed decision, my preference would be that they're here to present on these 16 agenda items.
All right, so with these comments, and somebody should have slapped me, because the other agenda items I have done, I did not go to public comment after each of them like I was supposed to. I'm just working and working. So for right now on this section, and because I don't actually know, there is a phone number in our attendees that I don't know who it is, but let's go to public comment on agenda item 11. Determine if there is anybody from AML present to speak with us, but I understand, and we'll talk about the reformatting of the agenda with them as actual presenters. But Ms. Tomlinson, can you please see if we have anybody for public comment?
To give public comment, please raise your hand in the Teams meeting or press *5 on your phone to take your place in the queue. I'm showing no hands are raised at this time.
All right, thank you. Well, that answers our question. Okay, so the organization of doing this is crazy. Before we do that and adjourn and I figure out getting them on the next agenda as presenters, can we please do the next one, because it is relatively easy little edits, which is agenda item number 12 for changes to 425.110, in which they changed the word guidelines to guideline schedule. And then in number 1, they changed guidelines to guideline schedule, and they put the parties may stipulate to a child support obligation, period. That does not comply with such guidelines. I think those are grammatical clarification language. I don't know that we need them to explain it to us. Do we have any committee comments on that?
Chief Pickard, for the record, I'm sorry to dominate, but Well, no, I'm not. I don't like the term schedule because we talk of schedules, for example, the low income table, right? We talk about that as a schedule. This is a process more than a schedule. Is there a better word? I understand what they're trying to do. Guidelines is a little too nebulous, but when I think of schedule, I'm thinking of a tabular schedule of operations, and this is much more than that. In other states, well, I know in Utah where I practice as well, it's the child support guidelines is the name. Guidelines is at the end, not at the beginning, but it's, you know, that makes more sense. But they are guidelines. It's not just a schedule. Am I the only one, maybe?
This is Joe Sanford for the record. I completely agree. I do not like the word schedule in here because I think it gives an incorrect idea of what it is. They'll think, oh, well, there must be a schedule for this, and really there isn't a schedule, right? It's a formula. So maybe formula is the better word, but at least when I have considered it, and I see their concern, which is, I mean, we have essentially lumped anything from 425, 100 on as guidelines. And some of those aren't necessarily the formula itself. Those are the whole guidelines themselves. And so I think if we want to have a word that we're going to say as, which I think is what they're trying to do, which is to say the calculation portion of the guidelines specifically, then we can create that. I'm not sure that I'm comfortable today saying that I have a perfect word for that. And even with it, I don't necessarily want to call it guideline formula either, because I believe it's better. I think there's a better way to describe it as, you know, a calculation forms or something like that. I think the word guideline in there at all is actually probably confusing, because I think the guidelines are designed to describe the entire set of our work. And then the formula, the calculation itself is, I'd prefer to call it child support formula or something closer to that rather than the guideline formula. And so I guess what I would say is, I think prefer obviously if someone from the AAML would do it, but if not, I do think that whether it's them or the committee itself, we probably should create a better defined term for, you know, a calculation pursuant to, you know, our methodology. But I don't like the term guideline schedule as that word. So if someone else has a great naming sense, feel free. Otherwise, I'll think about it and maybe have a better word to present at the next meeting. But that's just my thoughts.
Within the NRSs, it does refer to our committees to review the child support guidelines. So you're correct. In my opinion, the entire thing is the guidelines. And so when LCB utilized that word, they just really meant pursuant to all the rest of the guidelines, right? When they use just the word guidelines. So, but what I like about this, and that we did even without AAML present, is that we've identified, yeah, it probably needs some clarification. This is not it. And I am putting you down, Mr. Sanford, for working on that language for the next agenda. Okay.
Thank you.
There are sentences available. You'll find a word.
Yeah. So with where we are at today, right now, let's do public comment on that item before I screw up again. Ms. Tomlinson, if you could please accept public comment.
To give public comment, please raise your hand in the Teams meeting or press *5 on your phone to take your place in the queue. I'm showing no hands are raised at this time.
Okay, thank you. Where we're at right now is We have one other item on the agenda that is not relevant to the changes from AAML. It is regarding joint physical custody and the calculation there. Are we prepared to discuss that today, or do we also want to push that off to another agenda? Hearing no comments.
Yeah, that was mine, Madam Chair. I'm happy to push it off to the next one if the committee would prefer.
I think we need, and I started this meeting with, I think we need some more absorbing time on the changes. But also I will work on getting someone from AAML to be on the agenda as a presenter throughout the agenda without having to utilize public comment for them, so they can work with the committee and comment on the changes throughout. Unless there's another section of the AML changes that anybody wants to address today, I will entertain it.
Madam Chair, I'm just looking at 16, which I think is the one that Senator Pickard wanted to give me credit for, which I
yes,
think
I
sort of
that in between there. Yes. Agenda item number 16. Let me read it just real quick so that we're clear where we're at for the record. Agenda item number 16 is discussion and recommendations on the proposed language for NAC 425.140, and it's from Senator Pickard or Judge Hoskin, whoever wants to claim it. I put it at this point in the agenda just because it was the closest to the AML's changes on that same section. So trying to figure out a methodology to the madness right now. But would you two like to discuss that right now?
Yeah, well, that's kind of my thought process on it. And after reviewing what AAML did, they didn't do what we did, what we were tasked with doing, and that was to include in the child care calculation and as part of the calculation itself into 140, essentially moving 130 into 140. And we did that, and we discussed as a committee some concerns with regard to that, and added on page 2 of that exhibit F, which would have been under F, if applicable, because we had some concerns with regard to having to make Davis kinds of findings throughout. So that was, we were supposed to tasked with coming back 2 meetings ago, if I remember correctly, with language for the committee to approve. So I'm not sure today, given what's pending with AAML and the entire rework, whether we want to table this idea until we go through that, or if we want to deal with it and knock this out and just include that in the totality of what we're doing. I don't have a preference. There's really not a lot to it other than what we were tasked with doing. And Senator, I don't know if you've got something to add to that.
Thank you, Keith Pickard, for the record. I do think that this is the language we've settled on. I would suggest, because we can incorporate any changes to the AAML's modifications if we adopt theirs. I still think I would suggest we move this to the master document, that we adopt this. We can always change the master document later based on the AAML piece. And I would say the same thing, frankly, about the 160 portion too. I think it would make sense for us, just to keep things moving forward, to move this to the master document, and then we can modify the master document again if the AAML changes require it.
Okay, you just confused me. The 160 language is what part?
Wasn't that the one that I was working on separately?
Hey, look. I knew this was going to be confusing. Let's see, 160.
No, that was the 025.
Oh, 025.
So talking
sorry.
about bonuses. Yeah.
Okay, yeah. Okay.
I've got that language, by the way, but I'll forward that to you and we'll take it up the next one. But yeah, I just, because I felt like we had reached an agreement as to the, if applicable, to address Judge Rob's concerns about creating now a new entire list of findings they have to make. This gives them the ability to leave it out if it's not applicable with a simple statement. it was my impression that the committee was in agreement with this change, and so I would like to just see us move that on to, adopt it, move it to the master schedule, and then if we schedule, wrong word, the master document, and then if the AML changes warrant it, we can, because they don't address the language we've got here. And this language, I think, is important as we discuss the things of childcare.
And Madam Chair, do you need to take public comment on this? Bridget Robb for the record.
Yes, I will ultimately need to, yes, before we do action on it. Do we have further discussion by the committee on it, though? And to be clear, we're only talking about 0.140 right now, not the 025. That's a separate agenda item, so.
Right.
Chairwoman, this is Joe Sanford for the record. I am on board with adopting it. I'm looking at the language. Maybe I don't have the correct version or something. I have some concern with just the language in F. At the end of it, it says the court shall set forth its specific findings, if applicable, concerning, if applicable, colon. And so it seems like maybe there's one extra if applicable there. And so I guess it's one bold, and so
completely guilty. I think what probably happened is I knew I had to stick if applicable in, so I stuck it in and sent it to Senator Pickard, and he just forwarded on without editing my work, Senator.
That is absolutely what happened. Yep, it's like, oh, looks good to me, and off it went.
So which of the two if applicables would you two like to delete?
I would delete the first. I think the court shall set forth its specific findings concerning, comma, if applicable, colon. But it's 6 of one, half a dozen of another.
I just thought you wanted to make it really, really clear there was discretion there.
It could have been the subconscious intent. You never know.
Okay. Do we want to hear I don't think we have public comment, but do we want to try to hear public comment before we run a motion on this? Are we ready for that? All right. Ms. Tomlinson, can you please accept public comment on agenda item number 16?
To give public comment, please raise your hand in the Teams meeting or press *5 on your phone to take your place in the queue. I'm showing no hands are raised at this time.
All right, thank you. Do we have a motion for agenda item number 16 without the second, if applicable, or the first, if applicable?
So
sorry.
Judge Hoskin moved.
Okay.
I'll second it. Oh, I'll let Judge Robb have the second.
Thank you very much.
Okay. Any further discussion? Hearing none, all in favor state aye.
Aye.
Anybody opposed, state nay. Any abstentions? Motion passes. All right, that will go on the master document. Now, for clarification, because there was some discussion on agenda item 6, Senator Pickard, on your other edits, you were going to go rework it again, so I don't want to move it to the master document until you rework that language. Okay.
Right, and I've got that done. I'll send it to you as soon as we're done here.
Okay, great, because I'm going to have some weeding through this to get this cleaned up and fixed and figured out. So, okay. Agenda item number 26, discuss and approve ideas for future agenda items.
We did talk about serial parenting, so I just, if we want to include that in there.
Okay.
Yeah, and I was about to nominate Judge Hoskin to take a stab at the language. So, no, it's not like any of us need more to do, but I think that this is so important that I'm willing to take a stab. This is reminiscent of the AB 263 in 2015 that we did, where we put together a team of people. So maybe we create a subcommittee and a number of us can jump in. But I'm willing to take a stab at that.
We can, up to the extent, we just got to watch the numbers on it so that we don't have an issue with the Attorney General. So I'm fine with that. If anybody wants to reach out and let me know that you want to work on serial parenting, we will put that subcommittee together. I also need to work with DWSS because I know the agenda draft I had also had to discuss the next date, and that seems to be gone on this one. It does get it edited, I know, after it leaves my hands, but there's some things that need to remain on there. How far out do we want to hold our next meeting? What does everybody feel? I mean, one, I got to see about AML, obviously, and having somebody present. But does 2 weeks sound reasonable? 1 week sound reasonable? What are we looking at? Let's see, 2 weeks would be January 21st. Ooh, I have another board meeting that day.
As do I.
So the soonest, if we keep it on Fridays, the soonest, which we've been pretty consistent on, and I think it works well. The public's starting to expect it, so I think we need to keep doing that personally, but unless anybody disagrees. January 28th seems so far out, but I guess that's what we would need to do.
I'm going to be on a plane on the 28th, so I can't do that day.
Okay.
Not that I have to be here, but.
Well, and hopefully that's enough time, sufficient time for AML to take, to obtain somebody to do it for us that day. All right, so the next meeting will be January 28th. Unless we wanted to do it on the 21st and Senator Pickard can run the meeting instead of me.
Well, I don't like that idea either. But
well,
do we have to stick to a Friday? Yeah, no, it wouldn't be the first, but you do a much better job than I do. My question is, do we need to keep it on a Friday? Because frankly, I'm looking at the next
easier for Judge
6 Fridays. What's that?
If my only problem, Fridays, I don't have any court scheduled, so it's easy for me to make a Friday work. If it's another one, we've got to be a month out so that I can not schedule any hearings during those days. It's just, and I apologize for being the problem, but that's
Judge Rob shaking her head also.
I have exactly the same kind of problem, Judge Hoskin. Friday is easier for me as well.
Is February 4th too far just to accommodate everyone? No.
I could do the 4th. I was going to say that the only Fridays I have, because the interim judiciary committee is starting up and they want to do Fridays as well. So the only Fridays I have are the 21st, 4th, and 18th.
We could do the 4th, and we can just know that maybe we go a little longer than normal, and really, since we're pushing it out so far, maybe we can get some serious work done. Maybe we can actually get some language for serial parenting dug up, but the request from the committee is to really dig into this and the language, and we'll see if we can get some more exhibits out in front of everybody of proposals and ideas. I don't have a problem with that. There was quite a few heads shaking. Yes, is this okay for January 4th? Okay.
If we can
February.
February 4th, yeah.
February 4th, sorry. Yes, exactly. You don't want to go backwards?
Well, if you have a time machine, I'm going to be knocking on your door.
Madam Chair?
All right.
Yes. Since we're going to be out that far, would it be possible to get maybe a Word document of the master list sent out to everyone, so that if we're going to I know that I was talking about maybe changing a particular word probably throughout, and so that way maybe we can have some concrete language in front of everybody without that'll be on the correct document.
Yeah, yes, I can do that. I was trying to keep the master document down to the things that actually got approved by motions. So I didn't lose track of what we really actually approved. But I will send you a version of it and you can use it for your editing purposes, not a problem at all. And all I did was take the NACs off the internet and drop them into Word, copied and pasted, but that's it. But I'll send it to you, no problem. Okay, so I better make a comment to myself though to do that. Master in Word. Okay.
Madam Chair.
Other requests for future? Yeah.
Before we go, it is my recollection, and I could be completely making this up, but I thought, Senator Pickard, you were going to be asking LCB to maybe do some research for us, and it was, I thought, on this issue. So if we could get that by the next meeting, that would be really helpful.
I thought it was on joint physical custody in the calculation there.
Yeah, it's on joint, and the half the difference question. That was what LCB. Now, LCB, you know, Leslie and I both have the ability to ask LCB to do research for any potential legislation we're going to be bringing.
And
so,
Senator Harris.
Oh, and Senator Harris, right? Yeah. And for that matter, Assemblywoman Hardy, thank you. But anyway, because they lose staff during the interim, it makes it a little harder for them, but they can still help us out if we need to.
Well, as far as serial parenting goes, we're only looking really at one state. And I was wondering if we could maybe have them take a quick look at other states to see if we've got some different models to maybe kick around.
Sure, and that makes a lot of sense to have them do that. I was going to first look at NCSL. They usually have, if multiple states have dealt with these things. I know on the custody issue, they have a page dedicated to custody orders. So I was going to go there, but I can certainly have them look into it as well.
Okay. So on documents, I'm going to send that master in Word, and then also I'm going to forward that Wisconsin update if anybody's interested in it, just to see it. Any other documents we need for our next meeting? I want to make sure and I'll try to clean up this language, make it easier to follow this thing, but best I can.
And Madam Chair, speaking of the 425-080, I don't think that was on today's agenda. Even though I had tried to get them to get me the response before today, but let's put that on the next agenda because I should have their response on that. I know that in the presentation last time, the representation was that 23 states do it the way we do. And in my research, I did not find that. So I need to, I want to get that response from LCB back because they're looking at, I added that to the task. And so I should have both answers, both what other states are doing and then how many states are doing, what we do, which is the entirety of the difference transferred to the obligee. So anyway, if we can have that on the next agenda.
You said 080, but
isn't it?
Are you talking about agenda item number 24?
Oh, sorry, it's NRS. It's NRS 125B080, which points to 425-115. Sorry.
That's okay.
I was just looking at part of the discussion I had with LCB. So it's 425-115 sub 3.
Okay, and I have that on there and I have it to stay next time. Okay. All right. Anything else? right.
Kathy Baker for the record. When we're talking about the joint physical custody, one of the things that I was noticing when I was reviewing this is that we didn't really address like a shared custody arrangement. In this particular, NAC 425.115 assumes that they have joint physical custody of at least one of the children. But for instance, we have cases where there are two children and each child is with one parent. We have a case where there's, it's the Miller cases that we didn't really, I thought we had addressed it, but it's not showing up in 425.115. And I'm wondering whether we should revisit that since it's not addressed.
It is addressed.
Yeah, I thought we addressed the Miller question because we differed from the Supremes, and we went with Judge Hoskins' remedy, as I recall, didn't we? I'm looking through the statute right now.
It is in 115. If you look at number 4, if the parties have
there it is.
two or more children, yeah, it goes on. But yeah.
Each party has joint physical custody of at least one. To me, and maybe it's just the way I'm reading it, it means they share joint physical custody of one child, and then they maybe have primary custody of another child. But what if they don't have joint physical custody of any of the children? They just have, one of them has one child and the other one has two children. And I if I'm missing it, please, let me know. But I'm not really seeing that addressed in this, and I thought we had intended to do that.
All right, so I will add subsection 4.
Yeah, that's a great point. I'd missed that, but that's a great point.
Okay, so I will add subsection 4. And the summary is basically for the agenda: if no one has shared custody, right?
And it may be argued that sub 2, you would just calculate the way that you would normally, that you've got obligation for one and they've got obligation for one, and they get offset, whether we do Senator Pickett's proposal or something different.
Well, I want to be careful. Yeah, we'll discuss it. I'll just get it on the agenda so we can talk about it. I want to be careful because it's not an agenda item right now. So, okay. As one kid. Okay. Any other agenda items? All right, let's take public comment under agenda item number 27. Ms. Tomlinson, if you don't mind.
To give public comment, please raise your hand in the Teams meeting or press *5 on your phone to take your place in the queue. I'm showing no hands are raised at this time.
All right, thank you. We're not as popular as we used to be. All right, and I was corrected that also I don't need a motion for adjournment because it's my prerogative to adjourn the meeting. So I guess I'm adjourning the meeting, everybody. Thank you. I will see you on February 4th at 9 a.m. again. Thanks, everybody.
Bye, everyone.
Bye, everybody.